Greetings. I'm Richard Neymark, SVP of ICDR and AAA, American Arbitration Association. And I have the privilege of being the moderator of this next section, which is entitled Conflicts of Interest and Codes of Conduct. Especially a pleasure because I get to sit here and look perceptive and intelligent and mostly listen to the panel address the issues of importance. We have a great panel for the issues that we're discussing here, but I want to just briefly talk about why we're having a panel on this particular topic or set of topics. And I would say at the outset, reflecting a bit what was said previously, that the arbitration process increasingly has a PR problem, public relations problem, perception problem, driven by really the success in the use of the process in spreading into a variety of areas. So we start with a very traditional, long time ago, commercial B2B type of arbitration, then we wind up with investment arbitration in the US and some other jurisdictions, consumer arbitration, very controversial, and a lot of misinformation, a lot of angst, a lot of concern about what's going on in this field. And in many respects, it's a shock to those of us, all of us in this room, to see the kind of verbiage that's used to describe the arbitration process and its various permutations, because all of us believe this is an honorable field. People are very ethical. They make decisions that are rationally based. And the process itself is maybe more than just a process in our minds. To many, it's a calling, it's a mission, it's a high point in the application of fairness and justice. But given all the new players and all the new areas of exposure of arbitration, it is not a given for everyone. So now we have to deal with people both inside the circle and outside the circle. I think a lot of this is also drawing on various sources of energy and angst from those who are anti-globalization, which causes a dramatic restructuring of the world economy and displacing a lot of people, a lot of anti-business sentiment, a lot of anti-government sentiment, a lot of anti-authority sentiment. And I think a lot of the sort of verbiage and the anger almost that we see is born of the insecurity that comes from these groups, the sense of disenfranchisement that comes with the restructuring of the world economic order, the feeling of instability in the world, distrust of foreigners. We're seeing more and more of that. This, by the way, is nothing new. All organized, civilized societies have a long tradition of blaming our judges and court systems and lawyers for all our ills. But now it's being transferred in many respects to the arbitration process because of the increasing dominance and importance of the arbitration process. But many of us in this field, I think, are still in a state of denial. We believe that this is a field that has been effectively self-regulated since the beginning and has adapted in many ways. You see comments from the naysayers, including in some very well-regarded publications, talking about who are these unelected elitists doing unknown, unexplained things behind closed doors. Very sobering. So the ethical and the behavioral assumptions that all of us in this room carry into the arbitration process are not a given, and they're not necessarily shared or even known by others who come in contact with the arbitration process. So we really need to move beyond our own assumption stage and be more concrete and transparent about the behavioral expectations of parties, about the ethical requirements, and to be transparent and vocal about it. We need to speak up for what is good and excellent about arbitration and continually renew it for the better, and be able to demonstrate it by people who are not necessarily part of the inner circle and initiated. So the guidelines we're about to discuss may be the right approach, maybe they're adequate to the task, or maybe they're not. I hope that we will be able to, this will enable us all to think more about how we shine up the reputation of the arbitration process, improve the process, and improve the behavior of the actors. So, with that said, we have a series of questions we assembled, and what we've agreed to do is each of the panelists will speak briefly on a topic for about 4 minutes, and then we'll open it to the rest of the panel for comments they wish to include. And we'll start with Mr. Zuleta. The question or the statement is that in recent years, scholars and practitioners have discovered the need for codes of conduct for both international commercial arbitration and investment arbitration. So far, the IBA has issued its guidelines on party representation in international arbitration, and the LCIA has approved its general guidelines for parties' legal representatives. So the question is, really 2 questions. Do the existing guidelines on counsel behavior respond to the critical issues? And more fundamentally, I would ask, what are the behaviors that we are trying to address?
Thank you, Richard. I guess with your presentation and Alexis' introduction, we have a sort of a general frame of what the issues are. But before setting the issues, we have, and you have correctly stated that, some relevant facts that I would say are undisputable. Number one, that arbitration is no longer what somebody called the realm of the founding fathers. It's a totally different environment with new players, and new players that go from transnational law firms to practitioners in small jurisdictions that are intervening in international arbitration, which was the case 15 or 20 years ago. Number two, new players that are not necessarily lawyers or counsel or arbitrators, ONGs, third-party funders, the European institutions. 3, the realization that local rules are not sufficient because they go to a plethora of conflicting rules that may apply to one single case. So it is clear that local rules in connection with conduct of counsel and arbitration are not sufficient. 3rd or 4th, that there are clear disparities in counsel and arbitration conduct as a result of cultural differences, and conduct cannot be qualified as ethical or unethical based on biased cultural perceptions. Counsel or arbitrators may act ethically but differently. It's a cultural approach. And thus, therefore, this is a matter of trying to create ethical transnational rules. Is a matter of creating rules for each institution, or is simply a matter of leveling the playing field as opposed to discussing ethical matters? And in this context, the key issues that have been identified, and I'm referring here to the debate that took place in the arbitration committee of the IBA at the time of the guidelines on party representation were discussed, can be divided in, I would say, in 3 areas: counsel conduct, arbitrators' conduct, and other players' conduct. In connection with counsel conduct, there are a number of issues that have been identified, and that were identified in that discussion, that have been identified in other publications, particularly the publications by a paper from Doak and the excellent book from Catherine. And they can be summarized basically on the following. Number 1, communication with arbitrators, the extent of the communications with arbitrators, ex-party communication. Number 2, submissions to the tribunal, submissions on issues of fact and on issues of law. Third, information exchange and disclosure, particularly exchange of documents and the like. Witness and experts, and remedies for misconduct, and whether the arbitrators should have the power to impose sanctions or penalties or whatever on the parties in the course of the arbitration because of misbehavior. In connection with arbitrators, I would say the key issues are, number one, the duty of disclosure, which is of course related to independence and impartiality. Number two, fair conduct of the proceedings. Three, again, ex parte communications, of course, confidentiality of the proceedings, and timely rendering, and I would go further than what Alexis said. It's not only time rendering of awards, it's timely rendering of decisions. We've seen cases, and we were discussing that with Jose Emilio before, of 3, 4, 5 months waiting for a simple procedural decision to go out. And that's part of the conduct of arbitrators that I would say is not acceptable. And then last but not least, the conduct of other players, expert witnesses, third-party funders, and other third parties. So far, and I would conclude these brief remarks with that, 2 efforts have been made to address these issues. Number one, the IBA guidelines on party representation that, as you know, were adopted by the IBA in 2013 and increasingly have been adopted in procedural order number 1, either because the parties voluntarily adopt them or because the arbitrators suggest the parties to adopt them. And from empirical experience, for what I'm seeing in a number of cases, they are being adopted more and more, despite that, you know, the criticism that some people have raised on the guidelines that do not intend to rule on universal guidelines on ethics, but on basically party conduct in the arbitration. And the second one are the LCIA rules of 2014 and the annex that adopted some guidelines on party representation with a different approach, but the issues tackled there are similar to the ones contained in the guidelines. The question, of course, as Richard was saying, is, number one, is this sufficient? And the second question is, are these the issues, or are there other issues that should be raised and discussed in connection with behavior of counsel and arbitrators in international arbitration?
Doug.
Yeah, I certainly don't disagree with anything that Eduardo has said, but I would perhaps put it slightly differently. I would say that there are 2 primary issues that are involved here and to which the IBA guidelines respond. The first is what's referred to sometimes as guerrilla tactics, that is, tactics of some parties and counsel in attempting to undermine the fundamental fairness of the arbitration or to set up claims to vacate the award. Conduct designed to delay the proceedings unduly, and conduct that raises the cost of the proceedings for all the parties or perhaps doesn't pay advance on costs and creates problems for the arbitration. So I would first of all categorize one aspect of the problem as these guerrilla tactics that we sometimes see. The other conduct that I would say is at stake is leveling the playing field, and Eduardo referred to this, that we do have cultural differences, and counsel from different regions do have different ethical obligations. Sometimes those ethical obligations between counsel, in fact, are quite the opposite of one another. And so I think the IBA guidelines was designed in part to try to provide a level playing field so that the arbitration process will be fair. And I would say that the IBA guidelines and the LCIA annex, and if I read the earlier PowerPoint, that there may be a new AAA ICDR protocol coming down the road on this issue. I would say that those are designed to address exactly these kinds of issues and to give the arbitrators better tools to ensure the fairness of the process for all the parties.
So for the rest of the panel, I had a professor at university who used to say you cannot legislate morality or ethics. So are these guidelines sufficient? Will they be effective? What do you think? Catherine?
I'm not going to touch the legislating morality question, but I will say that I think, alluding to some of the remarks that were made in the introductions, that one of the primary audiences, obviously, for an ethical code are the attorneys who will be regulated by it, which was, I think, very outlined very nicely by Eduardo. But the other constituencies, when we heard referenced in the introduction, more and more international arbitration, certainly investment arbitration, but not only, also commercial arbitration, is being looked at by outsiders. And when you ask outsiders, or when you tell outsiders, oh, by the way, all these attorneys are from different countries, and you talk, if you were, I wouldn't actually suggest it, to tell them about some of the statistics that have been done in some surveys about how much attorneys understand about what ethical rules apply to them when they are operating outside their jurisdiction in an international arbitration. And in fact, most of them don't know which rules technically apply to them. And they also don't know which rules might apply, what codes of conduct might apply to their opposing counsel. And those are some startling observations, the idea that you could operate in a tribunal without knowing what you are supposed to be doing and what is expected of your opposing counsel. And while that has caused some of the problems that were described by Eduardo and referenced by Doak in terms of guerrilla tactics, it's even more shocking to those who look in from the outside. As I think was made as one of the jokes in Richard's introduction, lawyers are always a little bit looked at askance. But when they're told that there are no rules or no known rules, or it's unknown what rules govern them, that only increases the conundrum.
Okay,
Well, actually, I'm going to touch upon some of these issues in my little speech. So maybe
okay. Well,
I'll reserve
then
for
let me introduce that. Question is it sufficient to have different codes that the parties adopt in each arbitration? In other words, like the IBA guidelines or guidelines that will be adopted by each institution. Or, as has been suggested by the Swiss Arbitrators Association, should there be a universal code? And the follow-up to that is, how can it be adopted and enforced?
Yeah, so for those of you who are not familiar with the ASA initiative, it is a proposal to create a global ethics body that, as I understand it, would be composed of delegates from all major arbitral institutions and organizations, and that would be tasked with the disciplinary oversight and sanctioning of all lawyers participating in international arbitration. It's attracted quite a bit of controversy. It's been derided by some as a proposition that cannot be taken seriously. I think any well-intended proposal deserves careful consideration. And so, having carefully considered it, I personally don't think that such a new set of institutional machinery, even if it were to come into existence at some point in the future, which I doubt, is what the system needs. I think what the system needs is a practical, workable solution for an immediate problem. And before we venture out into what may be prohibitively challenging terrain, I think we should first look again at what the system already offers, what tools are already there, and whether they are being used to maximum effect. And personally, I think that they most definitely are not. And a bee in my bonnet here is the example of cost orders to sanction some of the most frequent instances of misconduct in guerrilla tactics. You know, the repeated frivolous arbitrator challenges, the frequent specious applications, false evidence, false statements, and so on. For cost orders, sanctioning these things to have a meaningfully persuasive effect, they obviously have to be issued during the proceeding, immediately after the misconduct has taken place, and they shouldn't be rolled up and fudged into the typically nebulous cost section of a final award when it will no longer have that meaningfully dissuasive effect. Now, in practice, or at least from what I and colleagues and friends that I discussed this with have seen, it is very, very rarely done. And I've always wondered why, and I've asked the questions the question in other forums, and the only plausible answer that I've received so far is that when it is a matter of discretion to slap a peer on the wrist or not to do it, then it creates significant discomfort for us as arbitrators to do that. And I think this is where a contractually binding code of conduct can actually make a meaningful contribution. If the arbitration rules themselves expressly proscribe the offending conduct and expressly prescribe as a necessary and immediate consequence a cost order, I think arbitrators will be applying those rules no matter what the level of personal discomfort may be. So I personally very much like the idea of making conduct rules, council conduct rules, a part of the contractually binding arbitration rules. And that leads to the question that Richard asked, which is, well, what's the best way to go about that? Is it waiting for the parties to adopt, in each case, the IBA guidelines as part of the applicable rules? Is it for each institution, like the LCIA and perhaps now AAA ICDR, to adopt its own set of rules? Or is it for all major institutions to get together and try and agree on a single code of conduct that they all integrate into their rules? On that question, to some extent, I admit I'm actually relative agnostic, because what I'm really interested in is that a decent code of conduct does become contractually applicable to the parties, no matter how we get there. But everything being equal, I do think that a case can be made for a single code of conduct to be integrated into all of the rules of the major institutions. And I say that for two reasons. I heard, Eduardo, what you said about you seeing the guidelines being increasingly adopted by parties. It's all, a matter of, the universe that we're trying to test, but the anecdotal data available to me suggests that we're still a long way off parties actually doing that in a systematic way, and so it does leave, at least for a considerable period of time, still a lacuna. The alternative of each institution adopting its own rules, I don't know whether we're heading there. We have now two major institutions that have done it or will do it. But even if all major institutions adopt their own code, I do wonder whether that isn't suboptimal to a single code. Why should I be subject to different standards of conduct depending on whether I'm appearing before an ICSID tribunal, an ICC tribunal, an ICDR tribunal, an LCA tribunal, SIAC tribunal, and so on and so on? Or put it differently, why replace national differences in matter of ethics with institutional differences? And if the answer is, well, but all these codes are going to be more or less the same anyway, then why not agree on a single code of conduct? And the last point I'll make before I'll stop, on the point of double deontology, and as Doug rightly pointed out, all of what I just said all goes to basically guerrilla tactics and disruptive behavior. But I think a single code adopted by all the major institutions and made part of their rules can also make a contribution in respect of the conflicts between national rules. Because on the one hand, where national rules are silent, obviously if you do have the code of conduct as part of the applicable arbitration rules, you will have an accepted international standard that will apply and will be enforceable in the case. But also, and this is in a way the more difficult problem, I guess, sometimes international practice is more permissive than some national codes, and we all know the example of witness preparation. But I think if all major institutions adopt a single code with internationally accepted standards, that must put significant pressure on the relevant national bar associations to include the kind of carve-out that bar associations have introduced in countries like France, Switzerland, and even my own Belgium, where they make it clear that for witness preparation, basically members of that bar are released from what otherwise would be the national standards. So I think there is something to be said for that, but I will say no more.
Okay. Catherine?
So I actually, I think to the extent we're looking for an I'm going to slightly disagree, even if it's very rare, with Gaetan. I think to the extent we want an international code or a harmonized code, we have the first, certainly, iteration of that in the IBA code. I do think there's something valuable, and so I really applaud the effort by the AAA and ICDR to add to the LCIA's effort, because I think that there is no such thing as universal ethics. That's why every different legal system has important differences. And I think among arbitral institutions, there may also be differences. So, for example, if you're appearing before the DIS, a German arbitration institution, or the Vienna arbitration institution, it might be much more typical that parties under their rules agree that there will not be document production. Okay? If there isn't document production, then a whole chunk of the rules that are currently in the IBA guidelines on representatives are essentially useless. I think also with some Asian arbitration institutions, for example, mediation arbitration hybrids are much more common, and there might need to be specific ethical rules that are attendant with those institutions' administration of those processes. So for those of you who might have more reading time, in my book, this is something I take up because I don't think there is such a thing as a single uniform body of ethical guidelines for attorneys worldwide, because the ethics of an attorney in a particular context is determined by the functional role that they perform in that context, and that functional role is in turn determined by the procedures by which they're bound. In international arbitration, at least, some of the most core procedures are included in an arbitration institution's rules, and so I could see some meaningful, important differences among institutions. I do, however, agree with Gaetan that there is going to be a core set of principles and guidelines that will be universal among them. But I think it's important for arbitral institutions to be able to distinguish themselves and to tailor ethical guidance for the counsel who appear in their proceedings to the procedures that are unique to those institutions.
I might also point out that there's also a positive aspect to setting such rules or guidelines, and that is it can be empowering for people who are from one legal tradition and moving into another, for instance, on issues of witness preparation or document disclosure or issues of privilege, to more clearly define what are the boundaries and what is allowed as well. It's not all the cops.
Yeah, but there's a question here with the issue of the SAA proposal, and what is the goal we're trying to reach here? Are we trying to govern ethics, universal ethics? If that's the goal, we're not going to get there. Or are we trying to rule on conduct of the parties to try to, as the panel has posed, level the playing field, have a basic set of rules that everyone abides by in the conduct of the arbitration? If we're trying to substitute bars and get to a sort of a universal code of conduct with a substitute bar for this, we're not going to get there, because number one, it would require compromise, and number two, we will be fighting with the local rules of ethics that in one way or the other will prevail for the council. So what we're discussing here is a matter of leveling the playing field, preserving the integrity of the arbitration, or trying to set a conduct of universal rules of ethics.
So you can't legislate ethics, but maybe you can legislate behavior.
Yeah, I think that's why everybody on this table, at least, I think, is in agreement that creating this enforcement body to enforce ethical standards for all people participating in international arbitration is not something that we see as compelling at all. But I think the other question is, if you want the arbitrators to be the enforcers of basic ethics rules, mostly those that relate to the kind of things that disrupt proceedings, that causes people to perceive international arbitration as a system that doesn't work and that lacks integrity, then I think it does make sense, one way or another, to try and put together a basic set of conduct rules, because it will give arbitrators a framework and comfort to be enforcers, to be more enthusiastic enforcers. I gave the example of the cost orders. It is a mystery to me why it isn't being used much more effectively, because it could, and it could make a real difference.
So it sets an expectation also for the let's move to the next. Catherine, really two questions combined. First of all, to what extent should the powers and duties related to council behavior be vested in the arbitrators, which is what we were just referring to here? And secondly, is it sufficient to have guidelines that the parties voluntarily adopt, or should they be mandatory?
These are sort of questions that build on what we were just discussing. I am actually a big proponent of having the arbitral tribunals administer this. And a couple of reasons why, because you look at the other options, right? Do you want national bars to continue to have this function? Well, national bars exist to determine the content of rules and to enforce rules that were written for a national legal system. And in fact, the reason we have arbitration is because the conduct and the procedures are very different in international arbitration, and they are just not very adept at applying or enforcing rules that are other than the ones that they've promulgated and are used to enforcing. Apart from the issue that the conduct may have occurred in a language that they don't speak, and all sorts of other practical obstacles. National bar associations are just simply not institutionally competent to do that. I think almost by process of elimination, it has to be international arbitrators. I'll say a few words about why there are some obstacles to that. On the one hand, there's at least a question that was, I think, the original starting point for the Swiss Arbitration Association in challenging the movement now with the IBA guidelines, and that is that there are some national laws that raise hurdles to arbitral tribunals administering ethical rules. Even in the United States here, where it's very common for judges to, through sanctions motions, to effectively regulate the ethics, and they also participate with the bar associations in regulating ethics. But in Germany and some other jurisdictions, there are actually legal traditions and histories that make even courts imposing sanctions on lawyers an anathema. To the extent that those are historical trends, I think the efforts by bar associations in Belgium and France and Switzerland to get amendments to their bar rules for the narrow issue of witness participation suggests that there's room for lobbying. With regard to institutional competence and where the fact that it's a very short period, I think, again, also arbitrators, particularly in contrast to some sort of worldwide body, a regulatory body, they are the most institutionally competent because they witness the conduct. The conduct is embedded in procedures that the arbitrators have essentially provided for. They are the best suited to be able to evaluate whether conduct overstepped the line or not. Again, it is something that challenges the tradition in some jurisdictions where courts don't do that, but I don't think, in contrast to national courts or national bar associations, there's any possibility. I'll also add that bar associations have, as we saw a few decades ago, essentially opted out of this role by uniformly saying that foreign lawyers can practice, almost uniformly saying, foreign lawyers can practice in jurisdictions and not be subject to their local ethical rules. Bar associations have also historically, although it's more anecdotal, essentially taken a very passive role in regulating the conduct or misconduct of their attorneys acting outside their jurisdiction. Many bar association rules simply don't provide for extraterritorial jurisdiction for the regulatory powers of national bar associations or subnational bar associations, as is usually the case. The last point I'll make is a signal that I think that the arbitration community, notwithstanding some important voices of dissent, is very ready for arbitrators to step into this role. Although there have been some cases that haven't been quite as enthusiastic, I think the Hepp versus Slovenia case, in which the tribunal found that it had the power to disqualify counsel for alleged conflict of interest. What's striking to me about that case is not only that it was this important voice saying, essentially first asserting this power of arbitral tribunals, but there is a completely lost dissent in that case. Jan Paulsen, someone who's generally opposed to dissents, wrote a very vigorous dissent. But I have yet to be at a conference where anyone brings up the fact that there was this vigorous dissent. And when is it that Jan Paulsen said something emphatically, and we collectively ignore it? It's because I think that the international arbitration community was so ready for this pronouncement that this otherwise important voice sort of got lost in the conversation. For those, and I'll stop there because I'm at my 4 minutes, but I do think the arbitral tribunals are the ones best positioned, most competent. Not that there aren't challenges that need to be addressed, but especially if you consider the fact that arbitration is not a monolithic process, but it varies jurisdiction to jurisdiction and with different parties and procedures, that arbitrators are the only ones really positioned to be able to do it. Thank you.
How about the rest of our panel? And in particular, I wonder whether you want to address this issue of whether guidelines or rules should be voluntary or mandatory.
Yeah, well, let me say, I think generally I agree with Catherine. The arbitrators don't have a carte blanche power to address all issues of counsel discipline and ethics, obviously. But what they do have is the duty to ensure a fair hearing and equal treatment of the parties. And to the extent necessary to carry out that duty to make sure that the hearing, that the process is a fair process for all parties, then arbitrators to that extent have the inherent power to do what's necessary in terms of disciplining counsel to that extent. I think the IBA guidelines and the LCIA annex address exactly that issue, and I think that they address it appropriately. Now, with respect to your question, Richard, of whether it's sufficient for the guidelines to be voluntary and not mandatory, the IBA guidelines obviously provide some international consensus as to what the proper conduct of counsel should be, and I think that's an important first step. I personally would prefer and believe it's important that the conduct of counsel be regulated as mandatory. There are only 3 ways to do it that I see. First of all, by the institutions adopting some sort of mandatory rules for counsel through their own arbitral rules. Secondly, by the parties' agreement. Or thirdly, by a mandatory arbitration law in the situs of the arbitration. The easiest way to accomplish that is for the institutions themselves to adopt certain rules. You already have a set of rules out there that provide an international consensus. That's the IBA guidelines, and that would be the easiest way to do it.
Okay.
Yeah, I fully agree with Catherine on that the arbitrators should be the ones. And there's in addition a practical approach. Gaetan was commenting on this body of enforcement, et cetera, that was proposed. And it has been said that the IBA guidelines would result in additional guerrilla tactics, challenges, et cetera. But if you take that power out from the arbitrators, then what would you do? Suspend the proceedings and go to the court? Suspend the proceedings and go to the bar? Wait until the end of the proceedings and somebody else will take the measures that the arbitrators cannot take and that could have affected the arbitration? I think even from a practical approach is the right way to do it.
It also occurs to me that those who are most likely to adopt voluntarily such codes are probably the people who are least likely to violate the codes. So, we'll, in a moment, have a few minutes for audience comment or participation, and there's some microphones available for that. But I want to go to our last question in Doak. And the question is, should there be guidelines for arbitrators' behavior beyond what is contained in the IBA guidelines on conflict of interest or similar guidelines?
Yeah, here we're changing topics away from counsel conduct to arbitrator conduct. And let me give an unequivocal answer. The answer, in my opinion, is yes and no. And let me, however, try to set the stage so you understand to what extent I'm saying yes and what extent I'm saying no. Every institution's arbitration rules necessarily contain a provision already that requires arbitrators to be independent and impartial and requiring them to disclose any conflicts that might give rise to justifiable doubts. So the fundamental rule for arbitrator conduct is already mandatory within the arbitration rules of almost every institution. Now, some institutions have recently gone beyond that and adopted codes of conduct for arbitrators. The AAA ICDR, of course, has long had its ethical rules for commercial arbitration for arbitrators. And more recently, the Hong Kong International Arbitration Center, the Portuguese Chamber of Commerce Arbitration Court, and the LCIA, through its notes for arbitrators, have adopted some form of arbitrator conduct codes. Now, the IBA guidelines on conflicts of interest provide greater specificity as to what constitutes a disqualifying conflict of interest. And in my opinion, the IBA guidelines represent a well-accepted international consensus as to what is international best practice in this regard. So in other words, they provide a detailed interpretation of what the words independence and impartiality mean as used in the arbitration institution's rules, at least in practice. Now, in investment arbitration, we have recently seen the EU-Canada Free Trade Agreement contain a code of conduct for arbitrators. At least they publicly refer to it as a code of conduct for arbitrators. But mostly what they have done is adopt the IBA guidelines as mandatory for arbitrators sitting in CETA cases. In recent weeks, we've also seen the TPP, the Trans-Pacific Partnership Agreement, be released. It refers to a code of conduct for arbitrators to be agreed in the future by the committee. The debate in the EU over the TTIPs has referred at some points to a possible code of conduct for arbitrators. But the fundamental issue, when we get back to it, is one of impartiality and independence of the arbitrators, the lack of bias and the lack of any appearance of bias. But that already is provided for, again, within the basic fundamental rules of every institution, and we have the IBA guidelines providing an interpretive tool for that. So my general answer to the question is no, we really don't need any more guidelines for arbitrator behavior. And if CETA is showing the way of what we're going to see in investment arbitration, what they're going to do in the treaties or through the committees is simply adopt the IBA guidelines in any event. But I do have one caveat. Having given the answer no, now let me say yes. David Rifkin, as president of the IBA recently, and I suspect everyone has seen his speech, called for what he referred to as a new contract between parties and arbitrators. And one of his critiques was how long it takes arbitrators to issue awards after hearings. And he proposed what I would refer to as a change of culture in which arbitrators would get their awards out much quicker than they do now. Now, I strongly agree with that proposal, and I especially agree with it for investment arbitrations in which we see it taking 1 or 2 years after the hearing for awards to be issued, and in some cases even much longer than that. So I have reluctantly come to the conclusion that the culture does need to be changed in this respect, and either the institutions or the IBA guidelines need to be amended or supplemented to provide some deadlines that are reasonable for the issuance of awards.
Other panelists, comments? Go ahead.
So I think Doug covered the question of do we need more or less guidelines, and I'm going to instead talk about what the utility of them might be, picking up on Gaetan's earlier comments about frivolous challenges. I think one function of guidelines, particularly for arbitrators, is again this sort of external audience. Arbitrators have been very much the lightning rod for criticisms of investment arbitration. And one of the challenges that's been, or one of the critiques that's raised usually on the investor side, is the question of frivolous challenges. An interesting statistic from the ICSID statistics is that approximately 70% of all challenges to arbitrators are brought by states. And to the extent that investors complain about arbitrators, it's usually, as Doug said, because of delay. But the state's challenges are not usually based on delay. They're based on continuing disagreement about certain areas about whether they constitute a conflict or not. One of the important areas there is what might be called, it's a very clumsy term, an imprecise term, issue conflicts. But one of the things that drafting or attempting to reduce to specific guidelines, one thing that exercise does, it helps resolve outside the context of individual cases through allegedly frivolous appeals, questions that are on people's minds. Should this be the basis of a conflict or not? On some a disqualifying conflict of interest. To the extent that those questions can be channeled into a deliberative process outside the context of an individual case and provide guidance to parties on both sides and decision makers, ideally more guidance will reduce the number of frivolous challenges, because it'll be clear before you make the challenge which side of the line or where it fits in the guidelines. So as we think about whether we need more guidelines or not, one of the other things to think about is what function they play, not just in guiding the conduct of the arbitrators themselves, but in guiding parties in deciding whether to make challenges and in signaling to the outside world to some extent what the priorities of the system is where arbitrators are presiding in cases.
Gaten, do you have a comment?
Very little, really. Gives me great pleasure to say that I agree with every word that Doug has just pronounced. With respect to Catherine, the frivolous challenges, obviously, it intersects with counsel ethics, and I think it's one area where the more aggressive use, or maybe assertive use, of cost orders during the proceeding should be very seriously considered by arbitrators.
It is personally interesting to me to see the evolution in this culture, and in particular on the issue of conflict and challenges of arbitrators. Many decades ago, when I started in the AAA, it was quite common for arbitrators to be appointed who would have what are now considered extensive disclosure issues, often with both parties, and that was precisely why they were chosen for the case, because the parties knew who they were, understood that they were from their field, they're people they generally trusted and respected, and now we've gone completely reverse. Now we're driven by tactical considerations in sort of the combat of the case. We have just under 5 minutes, and I wonder if anybody in the audience has a comment or question or something like to raise, please come. And think about whether what we're talking about here is just a high-handed overreaction to things. Are we overregulating? Or also think about whether there are some specific behaviors that you'd like to see addressed. Please.
Good morning. My name is Luis Parada. I'm a partner at a law firm here in D.C. Before becoming a lawyer, I was in the military, and I attended the U.S. Military Academy at West Point that had an honor code, which in essence said we will not lie, cheat, or steal, or tolerate among us those who do. The toleration part is the one I want to talk about. To the extent that tribunals, for example, for some reason, for perception, because they don't want to act against somebody who they see at these meetings all the time, and they're best friends, and they're in an awkward position of having to judge whether that party behaved or that attorney behaved ethically, fails to act. To what extent should we, the other members of the bar, then take up as part of our internal code of ethics the no toleration part and go beyond and bring to the appropriate bar authority or national authority in the case when laws may have been breached, as we may have, for example, the Foreign Corrupt Act, and actually take action to make sure it's not just a perception problem, but to the extent that there's a real problem that some bad apples among us may be giving us all a bad name or international arbitration a bad name, that we take care of that if the tribunal fails to act, or if it happens outside of the arbitration. For example, if we become aware that during a competition to try to get a case, somebody else won, and then we find out that that is because there's some money going back to the client. So my question is whether we should adopt the code of ethics, either personally or as a community of practitioners of international arbitration, that would include a no toleration clause.
Panel, any reactions?
I'll just say that's interesting about West Point, actually under U.S. ethical rules for attorneys who are licensed in U.S. jurisdictions, I think every state includes an obligation by lawyers to report misconduct by other lawyers, and it's probably the rule that's most often broken. And it also precludes lawyers, which is also most often broken, from threatening to report opposing counsel for a strategic advantage. And again, that's also sort of honored in the breach more than the observance. I don't think that's a universal rule internationally. I don't think that that is something that most bars in the other parts of the world impose on lawyers. And I welcome other people from different jurisdictions in the audience to correct me on that. But one of the difficulties in requiring that in international arbitration is that it's not so universal. With regard to tribunals, I will say before the Rule 11, which is the rule of civil procedure that allows judges to sanction attorneys. The problem was that judges weren't doing it because they also have a sort of hesitancy to sanction attorneys. It is a much more acute problem for arbitrators who essentially rely on attorneys for future appointments. But I think we'll see arbitrators developing reputations for being able to manage proceedings, and as Doak said, make sure that there's fairness in the proceedings, and that might be part of essentially the reputation that they develop by making tough decisions and showing courage in the face of misconduct of counsel.
Mr. Moxley?
Charlie Moxley from New York. Speaking sort of from the trenches as a working arbitrator, I think my overall comment would be that it is still the case today that a very high percent of counsel in arbitrations, including some fairly large international arbitrations, are really litigators, and they're not arbitration specialists. So I think the significance of that reality is that the more we can have that is directly visible and that we arbitrators have to work with the parties on in what is really a small percentage of cases where the guerrilla tactics, which Edna has written about and the like, it's a small percentage of cases that come up. But when they come up, it's obviously essential that we deal with them promptly. But it's very helpful. I think to have it in the institutional rules is really the most helpful thing, because as Catherine said, you can't rely on the usual providers here, the bar associations and the states, and so you need a cross-institutional. It'd be great to have something really recognized broadly, maybe a universal thing, but then to have it adopted in the rules. So the litigators in the particular case could know this is the rule, and the arbitrator can say, I'm not sure yet if we're coming into this situation that's covered by this part of the rules, but if we are, you should all read this and think about it, before we get together the next time. So I think that approach maybe makes sense.
So providing concrete tools for the arbitrator, really to empower them to deal with these issues. I recall a number of cases over the years where arbitrators felt they didn't necessarily have the tools, and they had cases that were really, running beyond the boundaries and run amok. And you typically would get the question to the case administrator about, can I put sanctions on this attorney? Just desperately looking for something to try to control the behavior. So,
because I think a lot of us feel, that really we need to keep our eye on the ball. And the ball is hearing the evidence and deciding the cases. I mean, it's really the attitude that most judges have, to not get bogged down on the he said, he said, she said, as to the discovery. But, as a number of you sort of mentioned implicitly, it's very important to the integrity of the process that the side that is really following all the rules and the other side is misrepresenting and withholding and all, that be dealt with. So I think partially it's a cultural thing, for us arbitrators, that we really, notwithstanding the appointment dynamics and the difficulties there, what we have to offer is part of a fair process, that we're going to consider this stuff, even in the not totally egregious cases, but just the run-of-the-mill of abuses that can happen. So yeah, I mean, just simple rules, you can't do, make misstatements to the panel and withhold documents that have been directed to be held or you've agreed to withhold, and there it is, and here's a consequence, even if, the consequence is
Right.
discretionary.
well, the reality of our field is, in almost all the cases, one of the parties doesn't want to be in arbitration, and will do whatever they can to prevent the case from proceeding to the end. And sometimes both parties don't want to be in the arbitration. So it's a difficult process to manage. Yes, please.
what the panel would think is an appropriate sanction in the situation of an arbitrator who is very untimely in rendering an award. We hear this all the time. The idea of kick them off the tribunal defeats the purpose because you've already invested how many years, so that isn't very useful. I've heard people suggest that they should have a certain amount of their pay docked. It seems a bit almost unprofessional to me, and if they put the work in, albeit in an untimely way, I don't know if that's the answer, but I don't know what the answer is. So I'd be curious what you think is an effective sanction that will encourage timeliness, and I guess from a broad perspective as well as from that particular arbitrator in getting the case finished in that particular situation.
Maybe they should wear a red shirt for a year. Anybody have a thought?
Well, I don't know that there is a particularly good answer to that. I think that docking the pay sounds like a really good theoretical answer, but in reality, it doesn't work very well, I suspect. It probably isn't going to incentivize them to get the award finished very well. I think the answer is probably going to be more reputational, that for the future, the institutions consider that and don't reappoint them, and that whatever reasonable pressure can be brought by the institutions, by the parties, transparently, is used to try to move it along and try to get to that point. But I think ultimately it probably is a reputational matter and a matter of appointing them again.
And I think with that, we have run, we have one more?
Is there?
Yeah, if we can do it very briefly.
I'm Sharina. I'm a lawyer from Bangladesh. I just had a quick question. As Mr. Neymark had said, one of his professors said that you cannot legislate morality, but I also think that you cannot police morality if you cannot legislate it. But the question is, can you teach morality in a sense? So the question really is it an idealistic thought that in training of arbitrators, and this is also drawing from Ms. Rogers' statement that arbitrators often do not want to sanction the council because they fear that they will not be appointed in the later cases. But is it a possibility? Is it a way that you can train and teach arbitrators and counsel that the interests of all parties lies in avoiding conflicts of interests and in proper disclosure mechanisms?
Let me suggest that that is a good discussion topic for our coffee break, which I think we are having now. Okay. And we're to reconvene when? We're to reconvene a few minutes before 11.